if you're on an earlier flight. Don't do that.
Rules Committee will come to order, and thank you very much for joining us this afternoon. I want to thank each of my colleagues for their attendance, and as this Rules Committee considers two important pieces of legislation that will help to strengthen our nation's financial services industry while simultaneously protecting consumers and providing certainty for our economy. First, the committee will consider H.R. 992, the Swaps Regulatory Improvement Act of 2013. This legislation addresses Section 716 of the Dodd-Frank Act by providing banks the flexibility they need to effectively manage risk. As written, the Dodd-Frank Act prohibits the in-house execution of swaps by forcing all banks to house any swaps transaction in a separate, capitalized, non-bank entity. Federal Reserve Chairman Ben Bernanke said that such a move would, and I quote, weaken both financial stability and strong, prudent legislation. Legislation before us today would allow banks to continue to use the majority of these important financial tools to hedge risk and to operate their banks in a safe and practical manner. Second, the committee will consider H.R. 2374, the Retail Investor Protection Act of 2013. This legislation aims to prevent potentially conflicting definitions of fiduciary standards on broker-dealers and other financial services professionals. H.R. 2374 would require the Securities and Exchange Commission, known as the SEC, to finalize a rulemaking on fiduciary standards before the Department of Labor promulgates a separate rule regarding similar standards. By allowing the SEC to act first and to establish adequate definitions to provide effective oversight of financial services professionals, we believe that they would be in position and better positioned to enact this rule. So this legislation will prevent unnecessary, costly, and confusing requirements from the retail investor marketplace issue. I'm confident that today's legislation will promote a safe and more affordable marketplace for all Americans and encourage investment in the U.S. economy. I'm pleased today to welcome three very important colleagues, members of Congress who come first from the Financial Services Committee, the young chairman of the committee from the 5th District of Texas, Dallas, Texas, the gentleman Jeb Hensarling, the gentlewoman from California, the full ranking member, the gentlewoman Ms. Waters. Also, I would like to welcome to the committee the gentleman K. Michael Conaway. Michael Conway will represent the Committee on Agriculture today, and I'm delighted that all three of you are here with the knowledge that I would first like to start with H.R. 992. Without objection, anything either of you have in writing will be engaged and entered into the record. The gentleman from Texas, Mr. Hensarling, the chairman is recognized at this time.
Thank you, Chairman Sessions and members of the committee. I want to thank you for the opportunity to testify before you on the Retail Investor Protection Act and the Swaps Regulatory Improvement Act. The subject matter of these two bills may be somewhat technical, but the reasons why they warrant the House approval are easy to explain. A passage of these bills, we believe, is critical to helping all Americans, from working families in Dallas, Texas, trying to invest wisely in their children's college education, to farmers, ranchers, manufacturers, and small businesses who are trying to manage their credit risk. Both of these bills under consideration today make modifications of the Dodd-Frank Act. Both of these bills have received strong bipartisan support. One of them was reported out of our committee by a vote of 44 to 13. The other was reported by a vote of 53 to 6. I appreciate that after 3 years after its passage that there are many Democrats who are willing to address the shortcomings and some of the unintended consequences that we have seen from such a large and historic act as the Dodd-Frank Act. Mr. Chairman, I'm especially proud of one of the freshmen of our committee, Representative Ann Wagner of Missouri, for sponsoring H.R. 2374, the Retail Investor Protection Act. A way of background, Dodd-Frank gave the Securities and Exchange Commission the authority to write a regulation to hold broker-dealers to the same fiduciary standard as investment advisors. I'm not sure of anyone who has claimed that these differing standards of care contributed in any way to the financial crisis. Nonetheless, Congress and Dodd-Frank essentially decided to rewrite 80 years of securities regulation without first determining whether the cost of changing these standards or considering alternatives to reduce or eliminate any confusion that exists without ultimately threatening the availability of financial products offered by a broker to their customers. If the SEC writes a rule essentially harmonizing the investment advisor and broker-dealer standard of care, brokers will have to raise their fees, and middle working-class Americans who are saving for retirement or college savings will lose access to inexpensive brokerage services. Without a direct mandate from Congress, the Department of Labor has decided to propose new rules to hold broker-dealers who administer ERISA-covered retirement accounts to the ERISA fiduciary standard. It makes no sense for the SEC to hold broker-dealers to one standard and the Department of Labor to hold them to another. Compliance would be excessively burdensome, if not impossible. The Retail Investor Protection Act simply requires the SEC to consider the effects on brokers of holding them to the investment advisor standard before the SEC issues a rule to that effect. The bill also requires the Department of Labor to wait until the SEC completes its rules to minimize any conflicts among related regulations. As there has been increasing overlap between the Department of Labor and the Securities and Exchange Commission in the area of retirement plans, inconsistent rules will be confusing to investors and problematic for service providers to implement. I'm also equally proud of another member of our committee, Representative Randy Holtgren of Illinois, for his work on H.R. 992. Clearly, financial reform should not increase cost for bank customers, and manufacturers, farmers, and industrial companies did not cause the financial crisis. Yet again, regrettably, the Dodd-Frank Act has swept in thousands of companies that had nothing to do with the crisis and subject them to increased cost and layers of regulation. As currently constructed, Section 716 of the Dodd-Frank Act would limit the types of products a bank could provide to a customer to reduce their risk and protect their business from market disruptions. What you may not recall is how other safer garden variety derivatives that have been used every day, again, by farmers and ranchers and manufacturers and small businesses, again, they did not cause the financial crisis. They did not. They had nothing to do with it. But again, regrettably, one of the perhaps unintended consequences of Dodd-Frank is that they were included in Section 716 that requires financial institutions to spin off almost all of their derivatives businesses into separately capitalized entities. Customers would have to create expensive and new business and legal relationships with a new company to conduct most of their risk mitigation activities. That diverts funds away from job creation and business expansion at a time where our economy is still sadly underperforming and tens of millions of our fellow countrymen remain unemployed and underemployed. Again, this would increase transaction costs, which ultimately are paid by consumers. To keep costs low, the Swaps Regulatory Improvement Act relaxes the spin-off rule for relatively safe derivatives used every day by American businesses to hedge financial risk while preserving the requirement to spin off more risky derivatives. I encourage this committee to adopt a rule providing for consideration of these two common-sense bipartisan bills that reduce unnecessary regulation in the financial services arena, and by so doing promote stronger economic growth and more job creation. Again, I thank you, Mr. Chairman, and the committee for the opportunity to testify, and I stand ready to answer your questions.
Chairman Hirschling, thank you very much, not only for your thoughtful conversations, but also your, what I believe is support of the industry who looks to the SEC to avoid marketplace problems, and very clear. Gentlewoman from California is recognized.
Thank you very much. Mr. Chairman and members, I'm here on H.R. 2374, called the Retail Investor Protection Act.
As well as H.R. 992, the Swaps Regulatory Improvement Act,
And I'm going to start with H.R. 2374. And I'm pleased to have an opportunity to speak to you about this bill because I think it is inappropriately named the Retail Investor Protection Act. Before I discuss the legislation, I first ask that the Rules Committee make all germane amendments in order so that the House can have a fulsome debate on this important bill. I think it's important for members to have an opportunity to weigh in on this legislation, particularly since the Education and Workforce Committee waived their consideration of H.R. 2374. H.R. 2374 is an attempt to stop the Department of Labor and the Securities and Exchange Commission from protecting the average retail investor when they save for retirement. As you may know, the department has been engaged in a process for the last 2 years, that is, Department of Labor, to update an outdated rule outlining the fiduciary duty owed to employee benefit plans under the Employee Retirement Income Security Act of 1974, ERISA, and for individual retirement accounts, IRAs, under the tax code. Because the rules governing the rights of investors and the responsibilities of advisors are more than 35 years old, the department is attempting to modernize these rules in order to reflect the changing nature of the retirement marketplace. In particular, retirees now are more likely to rely on 401ks and IRAs and are less likely to have defined benefit plans from their employers. At the same time, financial products have become increasingly complex. Given these realities, it is necessary for the department to make sure that the professionals offering the advice that retirees rely on have a duty to put their clients' interests before their own. At the same time, the SEC is considering moving forward on a rulemaking that would impose a uniform fiduciary standard of conduct for broker-dealers and investment advisors. This would ensure that whatever the business model, if an individual is providing personalized investment advice about securities to a retail customer, they would have a duty to put that customer's interests before their own. This is particularly important as many retail customers are not aware of the differences in the standard of care owed to them by different types of professionals that offer financial advice. Both agencies are moving forward carefully, collecting the necessary data and responding to stakeholder concerns about preserving access to investment advice, particularly for individuals with small accounts. The department has pledged to repropose their 2010 rule based on stakeholder feedback, and the new chairman of the SEC is collecting additional data to inform a potential future rule. Given these facts, H.R. 2374 is the wrong approach. This legislation would make it significantly more difficult for both the SEC and the department to move forward. First, the provision requiring the SEC to do a new study documenting that investors are being systemically harmed or disadvantaged under the existing standard creates a high hurdle for the commission to overcome. I mean, that's typical, do another study, impede progress. Given this fact, it appears that the purpose of this provision in H.R. 2374 is to impose further roadblocks before the Commission could take action and provide for another avenue for a legal challenge of an SEC rulemaking by certain industry interests. Secondly, H.R. 2374 will prohibit the department from finalizing its modernization of the fiduciary responsibility under ERISA and the tax code until the SEC issued their rule. This provision would represent a historic abrogation of the department's unique authority. This would be despite whatever pressing need for an updated rule that the department may be able to document. Additionally, H.R. 2374 would prevent the department from issuing any rule, including exemptions from ERISA, which would amend the definition of fiduciary in any way until the SEC finalized their rule. Finally, H.R. 2374 seems premised on the faulty notion that the Department and the SEC are not coordinating, when in fact leadership of both agencies have met at least 4 times in the last 15 months on top of regular SEC department staff meetings. Additionally, in July 2013, the SEC and the department renewed a memorandum of understanding regarding the sharing of information on retirement and investment matters. Mr. Chairman, I want the department and the SEC to get this right. In fact, I have joined some of my colleagues on letters to the department over the last 2 years expressing concerns that its 2010 proposed rule related to fiduciary duty may be overbroad to have unintended consequences, particularly for retail clients with small accounts. However, H.R. 2374 is the wrong approach. We want to make sure the department and the SEC coordinate and reach a conclusion that protects investors while preserving access to investment advice. H.R. 2374 does not accomplish these goals. It would hold the department hostage to the SEC and make it much more difficult for the SEC to move forward. Now, while I've spent some time talking about 2374, I just want to conclude how important it is for elected representatives who are sent here to represent our constituents understand the responsibility for protecting investors, particularly as it relates to these retirement accounts. When we talk about 401ks and IRAs and how people are struggling, first of all, when we're living longer, to make sure that they know how to do their planning so that it will last them throughout their life. But we also know that the Department of Labor not only has a responsibility to these small investors, but since when do we tell anyone who is advising someone how to spend their money and how to invest their money that they don't have a fiduciary responsibility? That's outrageous. You tell someone how to spend their money, they lose all of their money, you take no responsibility because you're something called a dealer broker instead of an investment advisor. I don't think the members of Congress want to do that. I think that in the final analysis, when the question is raised about who protected the small investors, who protected workers, who protected people who have everything invested in these 401ks and these IRAs, who protected them, I think we want to be able to say, we stood up for you. And so I think this is absolutely wrong, and I would suggest that we have an open discussion with germane amendments if there are any. And since my chairman combined both of these, I'll just go into 992 if it's all right with you, Mr. Chairman. Is that okay?
Without objection, I would encourage the gentlewoman to do that.
Thank you so very much. Well, again, as I talked about our responsibility to protect the small investors and how we must support the idea that broker-dealers have a fiduciary responsibility, this is another area where we have a responsibility to protect the average person. You know, today, H.R. 992, the so-called Swaps Regulatory Improvement Act, is this. This bill would essentially repeal Section 716 of the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010, a provision that would force many types of swap dealing activities to be pushed out from banking institutions that receive public support and placed into a separately capitalized subsidiary. Members, I want you to know, when you give a statement like that, a lot of our members looked at us with their eyes glazed over and said, what is she talking about? What are they talking about? We're simply talking about this, that we do not want these big financial institutions placing us all at risk by gambling, doing proprietary trading, derivatives trading, with that money that's protected by the FDIC. We know a lot now about derivatives, and many of us have learned so much, and we understand very well what happened with the London Well and J.P. Morgan, and the fact that they rolled the dice on $6 billion in their London subsidiary or whatever, and they lost. And so, members, when you take a look at what is happening in this country, the members of Congress are behind on enforcing Dodd-Frank. And so the regulatory agencies are stepping up, and the Justice Department is now taking control. You see these big fines that's going on, whether it is HSBC or whether it is Jamie Dimon and Chase Manhattan or any of these big banks. We're bringing up the rear on this. All of a sudden, because of Dodd-Frank and the work that we're doing, despite the pushback, despite what is happening with the way that we're being opposed, the regulatory agencies and the Justice Department are stepping in, and they're doing what we should be doing. We should be doing the oversight. It should not get to a point where we're allowing these swaps to take place inside the bank. They have enough room to do swaps. There are a number of swaps that they can do. They're not all outlawed, but certain of them are dangerous, and they should not be inside the bank. The bank should have a separate subsidiary that's organized to deal with these kind of swaps, with these kinds of derivatives. And that's what this bill is all about. You hear a lot about the Boca rule. And while the SEC has been a long time in coming up with the Boca rule, that's what it's all about. It's all about helping to define the difference between swaps and hedging and market making. And so while, for example, Chase Manhattan wanted to say that they were just hedging in London, we all know the difference now, and we all know how our whole economy could be put at risk if we allow this kind of gambling and betting to go on. They'll make arguments about why it's so important for the end users, but a lot of this is simply about the banks using the depositors' money to do these kind of swaps with. So I'm not going to go into any more detail about it, but I'm prepared to answer any questions that you may have. So thank you very much, Mr. Chairman.
I thank the gentleman for her time. Anything she has in writing, of course, would be entered into the record without objection. I appreciate her comments related to 2374 and H.R. 992. I recognize the gentleman, Chairman Conaway, was here to testify for H.R. 992, so I'd like to advise the committee that that was what he was here for, and the gentleman's now recognized.
Thank you, Mr. Chairman, and members of the committee. I'm here to represent the committee's equities in H.R. 992. I completely agree with my colleague from Texas, Chairman Hensling's comments about those. I would simply add that Section 716 was dropped into the Dodd-Frank bill at the last minute. It was not vetted properly. It wasn't debated. It was way overreached. And 992 will not repeal 716. It will simply narrow the scope of 716 to asset-based security swaps rather than the run-of-the-mill swaps that banks use every day to help their customers and help their customers reduce their costs. And so it's not a repeal of 716. It simply narrows it to those swaps that were considered the most risky, which are the asset-based swaps. And with that, Mr. Chairman, I would urge the committee approve a rule that it deems appropriate and move this bill to the floor, and I'll submit my written record for the or my written statement for the record. And
Chairman Conaway, thank you very much. This gentleman from Texas, Mr. Henschling, the chairman, wish to engage further on 2374. If the gentleman does, he's recognized. The gentleman does not seek that recognition at this time. I'd like to yield my time to the gentleman from Louisville, Texas, gentleman, Dr. Burgess. The gentleman is recognized.
I thank the chairman. Chairman Henschling, yeah, I'm way over here on the end, the far right to you. Let me just ask you a question, because we heard Ranking Member Waters talk about the Department of Labor, the harmonization between the Department of Labor and Securities and Exchange Commission. I assume you all had hearings about this in the committee leading up to this, or when this legislation was considered?
Yes.
And as a result of those hearings, it was felt that there was not the harmonization that should be occurring between Department of Labor and the Securities and Exchange Commission, which is why the legislation was necessary to ask that, a 60-day waiting period after the rule is promulgated by SEC before this goes into effect?
Well, number one, this is Dodd-Frank provided for a discretionary rulemaking on this subject, not mandatory. And so this would, if this standard goes forward, it would be a radical change in the standards of which broker-dealers are held to and have been held to for over 80 years. And what the legislation does is it requires that before the SEC can make a discretionary rulemaking, that they at least determine whether or not it's going to harm the retail investor. And it can't mandate, but it does stay action from the Department of Labor, given that there's essentially joint jurisdiction here. So they give them an opportunity to harmonize the standard. But potentially what could happen here is for a lot of working Americans who are struggling again to save a little money to send the kid to college, saving for their retirement savings, an entire business model that has been around since our securities acts were first promulgated could disappear. And all of a sudden, when you see these advertisements on television, the $6 trade, the $8 trade, the $10 trade, that could be potentially a thing of the past. And so what this does, and again, this was something that was passed on a bipartisan basis. Over half the Democrats on our Financial Services Committee voted in favor of this legislation, is simply require that the SEC undertake a very thorough analysis and ensure that before they do this, that the retail investor is indeed harmed. And so there were hearings, and again, this is a bipartisan piece of legislation. Half the Democrats supported it.
I just have to say, you know, my limited experience, I'm a consumer of financial products, and my experience with brokers and dealers on the individual level, the small town level, has always been one based on a mutual feeling of trust and respect. I got to say, if it came down to a question of trusting the regulators versus trusting my local broker or dealer, I'd probably come down heavily on the favor of the broker dealers and would not want to see that product damaged or in any way restrained or diminished. So I appreciate the work that the committee has done on this. I appreciate you bringing it to the Rules Committee. I'm sure we'll have a robust debate and consider all aspects, but I appreciate all of it. Yes, sir.
If I could add one more, no, just to make, if it's not clear, broker-dealers are still under a legal standard in dealing with their customers. It's a suitability standard, but it is a different standard than the fiduciary, which would require them to know their customer in a way that they currently don't, which again is going to increase cost and a business model that for many Americans, it's important to their families that they have this business model in which to trade.
Thank you, Mr. Chairman. I'll yield back.
The gentleman controls time. Did gentlemen have questions for anyone else?
No, sir.
Gentleman did not. I thank the gentleman. I now have consumed my time and would recognize the gentleman, the Vice Chairman of the Committee, Mrs. Fox. Ms. Fox recognized.
Thank you, Mr. Chairman. I thank our colleagues for being here today and presenting this information. And I'd like to ask again, does the gentleman from Texas have any other questions he needs to ask? Does he need time yielded? No? Okay. I believe that the gentlelady from California wanted to make a comment.
I did understand that, and that's why.
And I'd like to recognize.
It is difficult. And
I'd like to recognize her for any comment.
Thank you very much. And if the gentlewoman would yield just for a moment, I did recognize that and was trying my very best. And I do appreciate the Vice Chairman seeing that and recognize that. I was going to come back to you when it was my time later in lieu of Mr. Burgess. Thank you very much. The gentlewoman is recognized. Yes, ma'am.
I did want to make sure that you understand that the ed workforce had no hearings. Workforce had no hearings. They waived jurisdiction on this, and this is something that should be noted in the record. And then I wanted to also add that the number of organizations that oppose this bill, the AARP, the AAUW, AFL-CIO, ASPIC, Alliance for Retired Americans, Americans for Financial Reform, the Association of Belltel Retirees, Certified Financial Planner Board, Consumer Federation of America, Financial Planning Association, Fund Democracy, Investment Advisor Association, National Council of La Raza, the National Association of Personal Financial Advisors, the National Association of Professional Geriatric Geriatric Care Managers, North American Securities Administrators Association, OWL, that is the Office of Midlife and Older Women, Pensions Rights Center, ProtectSeniors.org, Public Citizen, Wider Opportunities for Women. Of course, this all led by AARP. This is serious, and it is about fiduciary responsibility. And the idea that somehow the broker-dealers should not be held to a standard, a fiduciary standard, such as investment advisors, I just want to make clear. And thank you so very much for allowing me that time.
I'm very glad to yield time to the gentlewoman from California, and I respect the comments that she's made, but I have to say that I would like to associate myself with the comments that Dr. Burgess made. And if I have to make a choice between trusting my local financial advisor and the regulators in Washington, I'm afraid I'm going to choose with my local person who's going to do his or her darndest to stay in business and not mistreat people in their own communities. And with that, Mr. Chairman, I yield back.
Gentlewoman yields back her time. Gentlewoman from New York, the ranking member of the committee, is recognized.
Well, thank you. I'm really troubled with these. I think, like Ms. Waters, it's going to take the rest of our lives to finally see Dodd-Frank come into being. I know the lobbyists are all over the place trying to make sure we can kill him. This is apparently another attempt at it. What I understand about 992 is that what it does is requires financial firms to move their swaps test to an affiliate in order to retain access to FDIC. Is that correct?
What did you just say that again, please?
The 716, Dodd-Frank requires financial firms to move the swaps test to the affiliate in order
That's
to retain
right.
access
That's right.
to FDIC, but then prohibits the federal government from bailing them out. Is that correct?
Yes.
All right. Now, what does this bill do that changes the Dodd-Frank provision?
This would allow the kind of swaps,
The riskier ones.
yes,
Okay.
the riskier ones, to remain inside the bank with FDIC protection. The taxpayers would be on the hook for the bets that they make. That's all they are with these derivatives. And that's what we're saying. You can keep some swaps. You can do some trading, but there are some that just should not be inside the bank. They're too risky.
Well, on the second one, 2374, which is called Retail Investor Protection Act, I sort of doubt that. Keeps the Labor Secretary from issuing a rule. Again, I've been very much impressed with SEC and what they're trying to do, but I think probably the biggest shock to me was that Jamie Dimon himself called the Justice Department and said, I'm ready to settle for $15 billion for the London whale. It's all in day's work. And I think there's about between $5 and $6 billion now being negotiated on mortgage failures. This is just one institution.
Just one.
And yet, despite all that, and they're willing to, just pay that, just take that and hope we can call it quits or whatever, we haven't changed anything because Dodd-Frank never seems to get there. I think it's a disaster waiting to happen. I couldn't support it for anything, and I hope the Senate, again, do you have any idea whether the Senate's going to take this up?
No, I have no idea.
The administration policy says they strongly oppose 2374. It would derail important rulemakings already underway at the Securities and Exchange Commission, Department of Labor, that are critical to protecting Americans' hard-earned savings and preserving their retirement security. Talking about prohibiting the Labor Department from issuing a rule to protect investors until the SEC engages in and completes further study, and I believe they are working together.
Yes, they are.
So this is a little premature, to say the least.
That's right.
Okay, now the bill ignores the fact significant work has already been conducted in both agencies, and that they have included and continue to include the public, the industry, and numerous stakeholders in the rulemaking process. Two agencies are already working closely to avoid conflicting requirements for the regulated community. This legislation would hamper effective coordination between those two agencies. The bill would hinder efforts to protect consumers from conflicts of interest, which is very important, I think, among the brokers, the dealers, the financial advisors, and others whose incentives may be misaligned with the investors, potentially leading to deceptive and abusive practices. And haven't we seen enough of that?
Yes, ma'am.
So the administration is committed to ensuring American workers and retirees are able to receive advice about how to invest their money in safe, secure, and transparent financial products that is free from harmful conflicts of interest. These ongoing rulemakings are designed to protect trillions of dollars in retirement savings of millions of workers and retirees by ensuring that paid advisors and other entities do not place their own financial interests over those of their customers. It seems to me that it cries out after what we've been through to at least get that much done. This legislation would place an unnecessary obstacle in the way of these efforts to prevent such harmful conflicts of interest, which hurt businesses, consumers, retirees, and their families. And should it pass both houses, the president would veto it. He's not crazy about the other one either. They oppose that. Wall Street reform represents the most comprehensive set of reforms to the financial system since the Great Depression, and its derivatives provision constitute an important part of the reforms being put into place to strengthen the nation's financial system by improving transparency and reducing risk for market participants. Regulators have made meaningful progress toward full implementation of Title VII of the Wall Street reform, and while these efforts are ongoing, legislation to amend Title VII is premature and could be disruptive and harmful to the implementation of these critical reforms. I feel like I've seen this movie already and probably even read this book, so I couldn't possibly support these. Thank you very much.
Gentleman yields back time. Gentleman from Utah is recognized. Gentleman has no question. Gentleman from Massachusetts, no questions. Gentleman, Chairman Cole's recognized. No question. Does any member of the committee on the Democratic side seek the gentleman, Judge Hastings, recognized?
I would ask the presenters, and first thank them, that if the retirement security of retail investors is at risk within the current system of different standards of conduct, which this legislation, the title of it, recognizes that by calling it the Retail Investor Protection Act, why is it necessary for the SEC to first assess if retail investors are negatively impacted by different standards of conduct before being allowed to harmonize them? Yes, sir.
Again, this is a standard, the suitability standard that has been around for decades, that has allowed a business model that favors less expensive trades. People have the opportunity today, if they so wish, to have a financial advisor and pay fees for that. Many people, though, prefer to trade on their own account with very little advice, and that's how you have the less expensive trades that a couple of decades ago were non-existent. And so to impose essentially a new Washington fee upon working families who are trying to manage their own account and force them to perhaps pay for a standard that they can't afford could potentially harm them. And so what this bill says is essentially it directs the SEC, it doesn't direct the conclusion, but at least directs the analysis that they have to find that ultimately there would be harm if this standard was not harmonized. But again, this is a radical, I'm sorry.
Well, no, I was just going to ask, Mr. Chairman, how long do you think that will take?
I suppose you would have to ask the chairman of the SEC.
Well, you seem to know. You've introduced the legislation, and all I'm saying is if they have to do something in the way of determining the harm to an investor. I mean, we pass laws up here all the time that have unintended consequences. And rulemaking allows that. I would think that they will take that into consideration. My concern is it going to delay the process that has already been put in motion with Labor and SEC, undertaking their rulemaking provisions? And if it is going to delay it, how long is that delay going to take?
Well, in response to the gentleman's question, I would say it is my observation in my years of service to Congress is that the SEC can move rather rapidly when they so desire and less rapidly when they don't desire. And I think it is the opinion of the committee, again, this was a provision that was passed on a very strong bipartisan vote with half of the Democrats on the committee voting in favor, that believe that it is more important to get it right than to get it done necessarily quickly. I know that the Rules Committee has to take this up now, otherwise I'd be more than happy to make an inquiry of the SEC chair. But again, I think it was the considered opinion of the significant majority of our committee that it was critical before potentially upsetting 80 years of settled law to potentially having an incredibly adverse impact upon working Americans trying to save for college or retirement, that this be done right and that this will not be promulgated until the SEC could actually conclude that the lack of harmonization is having a detrimental impact on the retail investor. That has not been done. And
I thank you. I was just going to ask Ms. Waters if she had a comment regarding same.
Yes. First of all, let me explain that we have we've been dealing with the implementation of Dodd-Frank, and this is but one of the many issues that Dodd-Frank is trying to do some reform in. What has happened is there has emerged a way of blocking, of causing delays, of basically impeding the ability to get the implementation of Dodd-Frank in order to protect consumers and to straighten out some of the problems we've had with our regulatory agencies not paying enough attention. This cost-benefit analysis is one of those that has emerged as the major way by which to impede progress. And while this does not speak exactly to the cost-benefit analyses that we've been dealing with on some of the other issues, it's the same pattern. What can you do to create a delay to impede the implementation of Dodd-Frank? That's what this is all about. The SEC is considering moving forward on rulemaking that would impose uniform fiduciary standard of conduct for broker-dealers and investment advisors. This would ensure that whatever the business model, if an individual is providing personalized investment advice about securities to a retail customer, they would have a duty to put that customer's interest before their own. This is particularly important as many retail customers are not aware of the differences in the standard of care owed to them by different types of professionals that offer financial advice. And frankly, Mr. Hastings, I just don't understand. Even if you were going to err, you should err on the side of these small investors and the average person that's simply trying to have enough money in retirement, that simply have worked all of their lives. All they have is that IRA. All they have is that retirement plan. And we're just saying, don't let folks come in and tell them any old thing, conflict of interest, and not have to take responsibility for it. What's wrong with fiduciary responsibility? That's the main question here.
Well, I certainly agree with that. I was going to reference Dr. Burgess's and Dr. Fox's comments regarding locals. When I was in the federal judiciary, I had a series of cases, as did several members of the courts throughout Florida at the United States District Court level, that dealt with a subject that I had no knowledge of, since all of my stock is in over-the-counter stuff like groceries. So I don't have the problem that some people have. But I became very familiar with the term churning. And the churning was going on at that local level, and seniors were being put at risk with major amounts of money. And when I tried one of those cases, I remember that there was a group, Shearson, that was with American Express, and I called myself going to try to buy $2,500 worth of stock, and I had Toys R Us and some other apple orchard out in Washington, and the Washington thing just went off the board. I never did know why or how or anything, and my broker was the Shearson guy that ultimately went to jail, not about my situation, but a lot of them locals are the ones that are creating many of these problems. I just believe that it is vital that we allow that advisors act in the best interests of their clients. That seems to be a make-sense proposition. And to deny the Department of Labor and SEC to strengthen their protections for the rulemaking process seems to me to deny getting to the crux of the problem. I thank you, Mr. Chairman. I have no additional questions or comments.
Thank you, Mr. Chairman. I wanted to ask the ranking member, the chairman said something in his opening statement that struck me. And he said, surely bank reform should not increase costs for bank customers. We're talking about the little guy, and when you talk about costs for the little guy, every little marginal increase in those costs hurts the little guy a whole lot more than it hurts the big guy. Understanding this bill was not unanimously passed out of committee, but passed with a big bipartisan majority. Would you imagine among those folks who voted against it, and I think you were in that category, would you agree with the chairman's statement that surely bank reform should not increase costs for bank customers?
I would respond to that in this way. I know that more conservative members of this Congress are concerned about taxpayers and how their money is used, and whether or not they're being overly taxed, and whether or not they're being protected from overreach by the government. When you guarantee that with FDIC, you are protecting the average depositor. You're saying that the government does not intend for them to be harmed. And when you allow the big banks to take actions that will harm them, then your regulators have a responsibility, and your members of Congress do also.
Well, I tell folks back home when they're looking for bipartisanship that they should keep an eye on some of these big banks, because we may see that coming together of the left and the right around some banking reform to make folks not too bigger to fail, but appropriately sized for the risks that creates. Why go down this road of harmonizing a fiduciary standard? I'm an attorney, and I can tell you that being a fiduciary is an expensive obligation. I bought my first stock. I didn't get swindled by the apple orchard that Congressman Hastings was swindled by. I bought the Regina vacuum cleaner company, which if you are my age or older, you may remember, but if you are younger than I am, you do not remember, because they went bankrupt and I lost all of my Regina stock, all 6 shares that I had back in the day. But the brokerage fee of a small transaction like that was a huge cost. The opportunities that the chairman talks about that are available today on E-Trade or TD Ameritrade or Scottrade or where have you, those were not available. Why not just put out that banner that says these folks are providing a fiduciary standard, and in fact every retail customer today can avail themselves of a fiduciary standard if they want one. They just have to pay for it, and these business models don't provide that standard, because again, as someone who acts as a fiduciary and sees the associated costs with that, I just can't imagine how folks who are trying to wrestle with growing their nest egg, don't want to stick it in the bank, don't want to put it in 0.01% in a CD. They want to try to do something for their families. How can we not imagine that their costs are going to go up? And how can we not imagine that if they wanted to avail themselves of that fiduciary standard today, they already have business model opportunities to do
The
that?
first part of your question had to do with harmonization, and it makes absolute good sense. When you have regulatory agencies that have some responsibility for a different, certain area or subject matter, that they not be at cross purposes, that they harmonize so that you get rid of any confusion or, inability to understand what is being asked, because both of the agencies that have some responsibility are working in tandem. So that's number one on harmonization. Secondly, when you talk about imagining that it would cost more in order to ensure fiduciary responsibility, it seems to me our concern would be more on the side of if you don't have it and you lose everything that you have, that we should be more concerned about that than whether or not you're going to pay a little bit more to ensure fiduciary responsibility. I'm concerned. I watched what happened in this 2008 meltdown, and I watched people lose all of their 401k. And I want to tell you, for, single women who are now, mature, and this is all that they have, to try and go back to work is impossible because you're not going to get hired. And so this is all people have. And I think we should be more concerned that people are able to work toward a decent retirement and hold on to what they have worked for, rather than being concerned that, well, I don't like the regulatory agencies. I don't like Washington. We all work in Washington, whether we like it or not. And we're here for reasons. And the reasons that we're here is because our constituents send us here to look out for them. And I think we should do that in the best manner possible. And I want to tell you something. After all is said and done, people can vote to protect the big bank and the big bank interests and define that in ways that looks as if you're protecting the consumer, but it's not happening. The fact of the matter is Jamie Dimon walks away having dipped into every aspect of our economy outside of banking, putting a lot of people at risk and causing us to be faced with another recession if we allow, certain kind of things to take place. So I'm not going to go into all of that anymore because I get on a real soapbox about all of this.
I was going to say to the ranking member, that's an easy well to dip into for inflammatory rhetoric, but I don't think that the Scott trades, the TD Ameritrades, the E-Trades, that doesn't implicate the Jamie Dimons of the world in any way whatsoever. The folks who come to my office and say, listen, I had to choose my business model. I could have either gone out and worked in a fee-based operation, could have worked for the big guys on percentage, or I can go out and try to help folks who don't have much, but they want to have more tomorrow, and I'm going to try to help those folks succeed, but they can't afford to pay for the kind of fiduciary advice that these wealthy folks are getting, and so we've got to choose. I tell folks back home all the time, you've identified it exactly right. It's that continuum of freedom versus security. You would say we've all been sent to Washington to focus on that security. I would tell you, my constituents would tell me we've all been sent to Washington to focus on freedom. But it's along that continuum. Let me ask the chairman, because I am so concerned, Mr. Chairman, that this is going to eliminate choices for my constituency. I'd be in favor of having everybody hang out a big sign out in front that says I use the suitability standard or I use a fiduciary standard, but why aren't you going, why doesn't this legislation take away the choice from the FEC altogether? I mean, I heard the ranking member talk about how folks are suspicious there's just a delay tactic and a delay and a delay. Why don't we just go in and eliminate this opportunity for the SEC to regulate altogether? Why even give them the chance to go down this road?
Well, again, Dodd-Frank gave them a discretionary rulemaking, so I guess you're saying we could repeal that entire section, which is clearly something the committee could have done. We chose to work on a more bipartisan basis, and to some extent that's the answer to the question. But if I could, just to amplify some of your earlier comments here, it's easy if you can afford it to have a personalized investment advisor who pays for the cost of having that fiduciary standard. but frankly, lower-income people who may do one or two trades a year. And again, it is the suitability standard intersecting with modern technology that empowers the single working mom to put a few dollars away for their children's education. And so what's going to happen is they're going to pick up the phone and they're going to call and say, you know what, I'm thinking about buying 200 shares of Apple. You know, what is your investment report on that? And they're going to get one or two answers. Either one, well, we don't adhere to the fiduciary standard, so I can no longer answer that question, or send me a $100 check and sign this 100-page form, and then I'll be glad to inform you. And then all of a sudden you're denying investment advice that previously working moms could have, and now they can't have it. There is a cost associated with this. There's a huge opportunity cost, and we're at least putting the burden on the SEC to prove that if they're going to harmonize, that ultimately it does not hurt these individuals. Otherwise, with due respect to the ranking member, I just don't, again, know what Schwab and TD Ameritrade and E-Trade had to do with the financial crisis. I mean, two completely different entities and business models.
Well, it's not lost on me that you could have gone down that road that said, I just don't like this, and so we're just not going to do it. And instead you said, let's not do it unless we need to do it, and let's do a study to find out if folks are actually being harmed before we move forward. Because if folks are harmed, we certainly have a shared interest in trying to solve that issue. Mr. Conaway, the Ag Committee does not have an interest on that side, only the swap side of the equation. All right. Mr. Chairman, thank you.
Thank you, Mr. Chairman. I have one question of Mr. Hensarling, Chairman Hensarling, and that is, I'll give you a situation. You tell me if it meets the exemption that's found in H.R. 992. An expressway that owns roads that are toll and limited access, and they would delve into swaps. The question is, would that be an asset-based security, in that the asset of the road itself, which is maybe billions of dollars, and then the asset also collects tolls every day off of that. So my only question would be just, would that be exempt under the exemption here that says exemption is asset-based securities?
Well, the fiduciary, the regulator, has the ability to define what a structured financial swap is. So whether or not this one would meet that definition, I'm uncertain. If you'll give me a moment, I will consult here and see if I can answer the question. Again, under the statute, the regulator, prudential regulator, still has the ability to define what that structured financial swap that has to be kicked out. It doesn't sound like it would be one that would have to be pushed out, but again, ultimately, the call would stay with the prudential regulator.
Thank you.
Gentleman goes back to time. Chairman now recognizes himself at time on the gentleman from Texas, Dr. Burgess, and I thank you very much, Dr. Burgess. Mr. Chairman, it sounds like you and perhaps Mr. Dinan are either villains or common sense crusaders. conflict and one rule being usurped by the other. That seems common sense to me, and you've been pitched as a villain here today along with the gentleman, Mr. Diamond. And I don't know Mr. Diamond very well, but I do know he's made a lot of people a lot of money and cares a lot about the investor in this country. How would you respond to this? Or are you a common sense crusader or a villain?
Are you asking me or my wife?
If I will ask Melissa, she would give me the same answer, that you're an awesome dad.
Again, Mr. Chairman, what I would say is the real question is not regulation versus deregulation. It's smart regulation versus dumb regulation. Dumb regulation fails to assess the cost of the regulation on working individuals who in a very tough economy are trying to make ends meet. And so, again, what we believe is people go on increasing a huge regulatory burden. At some point, the sheer weight, load, expense of the regulatory burden has a detrimental impact on the creation of jobs at a time, again, when tens of millions of our fellow countrymen are either out of work, unemployed, or underemployed. And so why you would have two different standards is frankly beyond me. And so we believe, again, that the SEC should act first. They should ensure that ultimately, if they go forward with a harmonization, which is a radical departure from decades settled law, that they ought to know what is that impact going to be, again, on the working mom trying to save a few pennies to send their child, hopefully, to Texas A&M University one day. They need to have that. They have to have that knowledge. And ultimately, a lot of these costs are borne by the people that many claim they want to protect. And so I just cannot fathom that when you're looking at the purported benefits of a regulation, you wouldn't want to look at the actual cost and make sure that it still makes common sense. So again, Mr. Chairman, I think it's common sense. It's common sense to all the Republicans on our committee. It was common sense to half the Democrats on the committee. I'm sorry the ranking member wasn't one, but clearly half of her caucus believed this was a common sense.
I thank the gentleman. I want to thank all three of you for being here today. You have now placed yourself before this committee, and I want all three of you to know that we appreciate not only each of you coming up here, but we count on your testimony as this committee goes from issue to issue to issue. We do apply the lessons that we learn from you, from each of you, to many of the ideas that we have about how we can make our country stronger with an understanding about balance and working with a government to where we can help them to make the lives of Americans better and to keep our country stronger. So I want to thank all three of you. You're now excused, and thank you very much.
Thank you, Mr. Chairman. May I offer
the gentlewoman's recognized. I apologize.
That's okay. The statement, the administration's opposition for the record, may I enter that into the record?
Without objection. Does the gentlewoman have that in writing? Normally, the gentlewoman,
oh, she does.
The ranking
okay.
member, and thank you very much. It's a good prompting, and it's a healthy climate where you can bring that up also, and the gentlewoman, I'm sure, will enter that into the record as she always does. Thank you very much. Does the gentlewoman wish to enter that into the, without objection, the administration's SAP will be included. This now ends the hearing portion of H.R. 992, Swaps Regulatory Improvement Act, and H.R. 2374, the Retail Investor Protection Act. And the hearing is now closed. The chairman will now be in receipt of a motion from the gentlewoman, Vice Chairman of the committee, the gentlewoman from North Carolina.
Thank you, Mr. Chairman. I move the committee grant H.R. 992, the Swaps Regulatory Improvement Act, a closed rule. The rule provides 1 hour debate equally divided among and controlled by the chairs and ranking minority members of the Committee on Agriculture and the Committee on Financial Services. The rule waives all points of order against consideration of the bill and provides that it shall be considered as read. The rule waives all points of order against provisions in the bill. The rule provides one motion to recommit. Section 2 of the rule provides for consideration of H.R. 2374, the Retail Investor Protection Act under a structured rule. The rule provides 1 hour debate equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee print 113-23 shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions of the bill as amended. The rule makes an order only the further amendment printed in the Rules Committee report, if offered by Representative George Miller of California or his designee, which shall be considered as read, shall be separately debatable for 10 minutes, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in the report. The rule provides one motion to recommit with or without instructions. Section 3 of the rule provides that a motion to proceed with regard to a joint resolution of disapproval specified in Section 1002 of the Continuing Appropriations Act 2014 may be offered even if the joint resolution has not been reported or discharged, shall be in order only on the legislative day of October 29, 2013, or the legislative day of October 30, 2013, and shall be debatable for 1 hour, equally divided and controlled by the proponent and an opponent. Section 4 of the rule provides that on any legislative day during the period from October 31, 2013 through November 11, 2013, the journal of the proceedings of the previous day shall be considered as approved, and the chair may at any time declare the House adjourned to meet at a date and time to be announced by the chair in declaring the adjournment. Finally, Section 5 of the rule provides that the Speaker may appoint members to perform the duties of the chair for the duration of the period addressed by Section 4 of the rule.
The committee has now heard the motion from the gentlewoman from North Carolina, and I would yield myself for a discussion about the rule. The rule provides for consideration of H.R. 992 under a closed amendment process. Although the committee asked for amendments several weeks ago, none were submitted. The rule also provides for consideration of 2374 under a structured rule. The rule makes an order of the Miller-Conyers Amendment for consideration. Both bills have 1 hour of general debate and are subject to a motion to recommit. The rule also ensures that consideration of a resolution to disapprove of the recent debt limit increase occurs before our upcoming district work period. Finally, it includes our normal administrative provisions to assist with pro forma sessions during the district work period. This is a fair rule, and I support it. The chair is now open to discussion or amendment. Gentlewoman is recognized.
I move the committee grant H.R. 992 and H.R. 2374 open rules so that all members have the opportunity to offer amendments to these bills on the floor.
You've now heard the amendment by the gentlewoman from New York. Oh, I've got that one down, from New York. And is there further discussion? Hearing none, the vote will now be on the amendment from the gentlewoman from New York. Those in favor signify by saying aye.
Aye.
Those opposed, no.
No.
Let's
No.
have a roll call on that.
Gentleman, Mr. Cody is recognized for a roll call.
Ms. Fox?
No.
Ms. Fox votes no. Mr. Bishop? Mr. Bishop votes no. Mr. Cole? Mr. Cole votes no. Mr. Woodall? Mr. Woodall votes no. Mr. Nugent? Mr. Nugent votes no. Mr. Webster? Mr. Webster votes no. Ms. Ross-Layton? Mr. Burgess? Mr. Burgess votes no. Ms. Slaughter?
Aye.
Ms. Slaughter votes aye. Mr. McGovern?
Aye.
Mr. McGovern votes aye. Mr. Hastings?
Aye.
Mr. Hastings votes aye. Mr. Polis? Aye. Mr. Polis votes aye. Mr. Chairman?
No.
The chairman votes no.
Clerk will report total.
3 yeas, 8 nays.
The amendment is not agreed to, not agreed to. Further discussion?
I do have a
Gentlewoman is recognized.
4 yeas, 8 nays.
Excuse me, if the clerk will, clerk will please report total.
4 yeas, 8 nays.
The amendment is not agreed to. The gentlewoman is recognized from New York.
Thank you. I noticed that one amendment's been made in order. It's a pretty important amendment with a debate time of only 10 minutes. I move that we double that to 20, just for the debate on the amendment.
Just so that I completely understand this, is the gentlewoman talking about H.R. 2374 or H.R. 992?
2374. There's one amendment order. That's George Miller and Mr. Conyers. Want me to read it to you?
No.
Authorizes Department of Labor to issue a fiduciary duty rule, protects access to investment education and advice, ensures the availability of a reasonable compensation to financial service providers, requires a study of the effect of current investment industry practices on the standard of care provided to investors by persons providing investment advice, including the effect on low-income investors. I think a 10-minute pro and con debate on that is really too short. 20 minutes is not enough, but I'm asking for 20.
And I thank the gentleman. I am interested in further debate from the committee about this. In looking at the schedule, I know the gentlewoman is aware of the service that will be held on behalf of the former distinguished speaker. And I would, not knowing the entire schedule, we get things to the floor. I am well aware that there are an extended number of people, including former President Mr. Clinton, who will be here as well as others. And I was simply trying to, at the time we did this, do normal, regular things, but extending that in the schedule of trying to accomplish our work and still accomplish those necessary items. And so I would just see if there's further debate or if someone has an idea about that.
I believe that the Foley, is that 11 o'clock? I believe. Is it 11 o'clock?
3 o'clock.
3 o'clock.
Oh, well,
2 o'clock.
yeah. Well, let's see, we've got an hour debate equally divided, no, only one amendment, an hour on two of them.
Then we have the
2.5
rule.
hours is not so bad.
And the rule. Well, all I'm suggesting to you is that I'm trying not to, it will be a crunch day, and the gentlewoman still is further discussion.
Yes, I would. I think it's important, and most of the things we do here don't ever go anywhere. I'd really like to, this is very important given what we've been through, and I hope my colleagues will agree with me over here that we need a little time to discuss that.
The gentlewoman presses the case for her.
We have 10, we're asking for 10 more.
Yes, ma'am. Gentlewoman is asking for that. Is there further debate?
Mr.
The
Chairman,
gentleman from Georgia.
is the gentlelady saying that this bill is not going to go anywhere, and yet we should extend the time of debate that we talk about it? Or is the gentlelady saying this is an incredibly important bill that is going to go somewhere, and so it's important that we have a full hearing?
The health care bill, how many times now? 46?
Right.
I mean, obviously, we're not going to pretend we're really getting any legislation done.
I wasn't debating. I was just asking. I was genuinely asking the gentlelady.
I don't know. The Senate may take this up, but I'd certainly be surprised if they do. But that we've never let it stand in our way that this was never going to be legislation on anything we've done.
Further debate. Does anybody wish to be recognized? The chairman would wish to offer to the gentlewoman an agreement that, in fact, I will vote for the amendment.
Thank you.
Gentlewoman has asked for it. There are lots of times when we schedule things, and as a matter of fact, I believe I would be remiss if I didn't say that I felt like some other things should be debated hours longer.
Yeah.
The gentlewoman, I believe I could fall victim of supporting that at this time. So those in favor of the slaughter amendment,
Just need two more then.
signify by saying aye. Aye. Those opposed, no. Gentlewoman, the amendment is agreed to.
Thank you very much. I appreciate it.
Further discussion?
I have an amendment.
Gentleman is recognized for the purpose of the amendment.
Mr. Chairman, I have an amendment to the rule. I move the committee strike the section of the rule that allows the House to consider a resolution to disapprove the debt ceiling increase. The House should follow regular order. There is no reason why the committee needs to rush this purely political tool through the rules process. And if I could take a moment, just to build on what the gentlelady from New York just said. I mean, we've had 46 votes to defund Obamacare, and now we're holding a symbolic vote on the debt ceiling. And we have an immigration bill that's already passed the Senate and is sitting here waiting for a vote that would actually, if approved, which I'm sure it would be here in the House, would get the President's signature. There are bills waiting in committee to address our growing trade deficits, start rebuilding our crumbling roads, our runways, our railroads, to put millions of Americans back to work. But instead we are going to do another symbolic vote that doesn't do anything to move our country forward. It doesn't put anybody to work. So I think we should kind of end this game that we've been playing here and get to work on some real substantive work for the American people and maybe even help create some jobs. So with that, I yield back.
Jim yields back his time. I would offer the ideas that this is a privileged motion that any member could bring to the House floor, and what we're simply trying to say is, notwithstanding whoever, if they did choose to do it, we don't want to be called back during the week that we would be off. And so what we're trying to do is to put a more open time, a less open time frame, one which we could effectively manage and then be able to respond accordingly. And so I viewed this as a management tool by the majority leader, the gentleman, Mr. Cantor, where he could effectively allow this any member that chose to, or this member that would choose to do that, but put that into a time frame. So I do appreciate and respect the gentleman. I would vote no. There may be other discussion on that matter. If I see no further discussion, those in favor of the gentleman's amendment signify by saying aye.
Aye.
Those opposed, no. No. The noes have it. Noes have it. Further amendment or discussion? Further amendment or discussion? Seeing none, the vote will now be on the motion from the gentlewoman from North Carolina. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it. The ayes have it. The manager for this will be myself
And Mr. Polis.
and Mr. Polis. I want to thank each of my colleagues for being here for this very important Rules Committee meeting. Committee meeting is now ended.